Good morning and welcome everybody. It is now 10:02 a.m. And I am starting part one of this preliminary meeting for the application made by Highways England for the A428 Black Cat to Caxton Gibbet Road Improvement Scheme. We'll introduce ourselves fully in just a few minutes. Before we do that, just bear with me while I deal with a few housekeeping matters. Can I check with the case team that you can hear me? Ms. Gregory?
Yes, I can hear you fine.
And can you also confirm that the meeting recordings and live streams have started?
So I can see the recordings. I'm just waiting on the live stream. Just bear with me for one moment. Yeah, that's started okay. Thank you.
Thank you. And finally, are there any requests for reasonable adjustments or arrangements to enable participation in the preliminary meeting?
No, we've not been made aware of that.
Thank you, Ms. Gregory.
Okay.
Okay, and then just one other matter, which is that we will be referring a lot to the Rule 6 letter dated 9th of July, which is in the examination library, reference PD-005. We will also make some references to the letter dated 2nd of July with examining authorities' procedural decisions. Our assumption is that all attendees today have read and have access to both these documents. If you do not have these letters, then a member of the case team, then please speak with a member of the case team during the break or after this meeting, and they will make sure you know where to find these. On to introductions. My name is Menika Sahai. I have been appointed by the Secretary of State for Housing, Communities and Local Government as the lead member of the examining authority to carry out an examination of the above application. I'll hand over to the other members of the examining authority. Mr. Parkin, if we could start with you, please.
Good morning. My name's Andrew Parkin, and I've also been appointed by the Secretary of State as a member of this examining authority. I will be leading on agenda item 3 and taking you through the examining authority's initial assessment of principal issues. Pass on to my colleague, Mr. Scriven.
Good morning, I'm Matthew Scriven, also appointed as a member of this examining authority. Today I'll be leading on agenda item 4, which is the examination timetable. The examining authority's appointment letter can be found in the examination library with reference number PD-003.
Thank you both. Also present today are 3 members of the case team. Case manager today is Miss Michelle Gregory. Ms. Gregory is covering for Mr. Emery Williams, who you may have had some contact with previously, and Mr. Williams will be returning to case management in a few weeks. The case officers today are Mr. Edwin Maudsley and Miss Catherine O'Lone. I want to acknowledge and welcome those who are attending, who are watching the live stream today. And finally, welcome to the attendees in the virtual room today. We will be seeing much of each other in the next 6 months, so I want to take time for named introduction. When I call out the name of your organization, if attendees from that organization could please turn their camera and microphone on, state your name and organization if that's relevant, and for the sake of the recording and the live stream. We will keep reminding you to, throughout the hearing, to state your name and organization just for the benefit of the recording. So I'm aware that some of you will be speaking as well. We will invite you at relevant points in the agenda. So for introductions, if I could please start with introductions from the applicant's team. If you'd like to turn your cameras and microphones on.
Good morning, ma'am. Can you hear me okay?
We can hear you loud and clear, Mr. Linus.
Thank you very much. My name's Scott Linus, Queen's Counsel. I'm instructed by Wombledon Dickinson to represent Highways England. I hope you have received a list of attendees for Highways England in a letter of the 3rd of August. Apart from myself, we have Victoria Redman and Lorraine Hendry from Wombledon Dickinson, Anne-Marie Rogers, who's a Senior Project Manager at Highways England, Ted Doherty is a Project Manager for AECOM, Naomi Kretschmer, who's a DCO Lead for AECOM, and Jamie Gleave, who's the Environment Lead for AECOM, but we don't intend that they'll need to speak at the meeting this morning. It'll just be myself.
Thank you very much. That was very clear. and welcome to all of you. Okay, I will then move on to attendees from Bedford Borough Council, please.
Good morning. My name is Alistair Wren, obviously attending on behalf of Bedford Borough, covering most of our issues.
Thank you, Mr. Wren. I will move on to Cambridge County Council and attendees from Cambridge County Council. I understand we have Mr. Chris Portney.
Good morning. Chris Pulteney, Cambridgeshire County Council, also representing today as part of our joint approach, South Cambridgeshire District Council and Huntingdonshire District Council, so speaking on behalf of all three, and being supported this morning by Mr. Tyrrell from Pinsent Mason. Thank you.
Welcome to both of you. And I believe we have attendees from South Cambridgeshire District Council.
Yes, good morning. My name is Chris Carter from South Cambridgeshire District Council. I'm joined by my colleague Chengi Taravinga, also from South Cambridgeshire District Council. But as Mr. Portney said, he'll be representing us this morning along with Mr. Tyrrell.
Thank you. That's very helpful, and welcome to you both. Excellent. And now moving on to Huntingdonshire District Council.
Good morning, ma'am. Clara Kerr from Huntingdonshire District Council, and again working with colleagues across Cambridgeshire and being represented by Chris Pulteney and supported by Francis this morning.
Thank you very much, and welcome, Ms. Kerr. Right, I will move on to Bates Brothers Farms Limited. I believe we have an attendee from Bates Brothers Farms Limited. No, I don't think that we have an attendee from there. Okay, I will move on. Apologies. Transport Action Network. Do we have any attendees from Transport Action Network? Apologies. No, I don't think we have anyone from Transport Action Network either. We do have an attendee from National Farmers Union.
Good morning. Alice Charlotte on behalf of the National Farmers Union. I work on infrastructure projects across England and Wales.
Welcome, Ms. Charlotte. Thank you. And then I believe we have a representative for East West Rail Company.
Good morning, ma'am. My name is Howard Basford. I am a partner at the law firm DLA Piper. I represent East West Railway Company. I'm accompanied by Ms. Kirsty Young, who is from East West Railway Company as well.
Thank you, and welcome to you both.
Good morning.
Good morning. Thank you, and welcome everyone. I will move on to a few matters about the virtual event. And just to acknowledge that this is a virtual event, we, the Examining Authority, are attending the meeting from the Planning Inspectorate Office. We understand you might be attending from your offices and homes. Unlike in a physical event, during today's virtual meeting, you will only be able to see our heads and shoulders, which I admit makes reading body language more difficult. During the meeting, members of the Examining Authority may be looking down, taking notes, or viewing a separate screen. Similarly, if we are watching you speak, then it's likely we're not looking directly at the camera. It does not mean we're not listening to you. I want to just assure everyone that we do have our fullest attention today at all times. To avoid visual and noise distraction, only the panel member leading on a particular agenda item will turn their camera on. Again, please be assured that even if our cameras are off, you will have our fullest attention, and we will contribute with comments or questions as required. We ask the same of you. If you could please keep your cameras and microphones off. We will pause at various points and give everyone an opportunity to ask questions or to make comments. Please wait for those opportunities, and you should be able to use the raise your hand function on Microsoft Office Teams. I understand you have been told not to use the chat function, so I'll just remind you of that. No one is monitoring the chat function, so please don't use that. Virtual events cause fatigue, and so we will ensure that each session of the meeting is approximately 90 minutes. Noting that you may have already been in the arrangement conference for some time, it means that we will take a 15-minute break at approximately 11 a.m. We will resume again for session 2 at approximately 11:15 a.m. and go on until 12:45 p.m. If we've not completed the business of the day, we will take a longer break at that time and resume session 3 at 1:30 p.m. and go on until required up to a maximum of 3 p.m. If you do decide to leave the meeting during the breaks, you can rejoin using the same link provided in your invitation email. If you're watching the live stream, please remember to refresh your browser to resume each subsequent session. To ensure that we're able to finish the business of the day, please keep your representations brief and to the point. We have read carefully and in detail each and every representation that came in at procedural deadline A. When invited to speak, please introduce yourself by name and, if relevant, by organisation. This is, of course, important for the transcript, recordings and live stream. Some of you have made representations at procedural deadline A about the use of virtual procedures to carry out this examination. I'll invite your comments in just a few moments. This event is both live streams and recorded. The digital recording that we make are retained and published. They form a public record. They can contain your personal information and to which General Data Protection Regulation, or GDPR, applies. The Planning Inspectorate practice is to retain and publish recordings for a period of 5 years from the Secretary of State's decision on the Development Consent Order. Consequently, if you participate in today's preliminary meeting, it is important that you understand that you will be recorded and that you therefore consent to the retention and publication of the digital recording. It's very unlikely that the examining authority will ask you to put sensitive personal information onto the public domain. Instead, indeed, we encourage you not to do that. However, if for some reason you feel that it is necessary for you to refer to sensitive personal information, we would encourage you to speak to the case team in the first instance, and we would then explore with you whether you might actually provide that information in written format so that it can be redacted before publishing. Does anyone have questions with regards to this matter? Please use raise your hand function on Microsoft Teams. Okay, I don't see anything. Moving on, we do expect courteous behaviour at this meeting and indeed at all hearings. Please be patient, wait your turn to speak and do not disrupt or interrupt proceedings. Repeated interruption or disruption of the preliminary meeting after a first warning is in principle deemed unreasonable behaviour. Please be aware that an award of costs can be applied for and made against a person who is behaving unreasonably. I just want to say a few words about what's happened so far during pre-examination period. The examining authority has read all the application documents and all relevant representations. We have also received a few late submissions, which the examining authority used its discretion to accept, and these are listed in additional submissions in the examination library. In order to familiarise ourselves with elements of the application, we have undertaken unaccompanied site inspections of the route and specific locations in the surrounding area in June and July. A short note of the location we visited, the time of day, and weather conditions is published on the Planning Inspectorate National Infrastructure Project webpage, and we will, of course, keep this up to date throughout the examination. Mr. Scriven will talk more about unaccompanied and accompanied site inspection arrangements under agenda item 4. And that brings us neatly to today. The main purpose of the preliminary meeting, and this is important, is to discuss how the application should be examined and the process. It is your opportunity to influence the process. The substance of the proposed development is not a matter for discussion today. Discussions about representations about the merits and disadvantages of the proposed development are for the examination itself, which will begin after the close of the preliminary meeting. The examining authority will not be making any procedural decisions today or in part 2 of the preliminary meeting. We are noting all representations that are raised here today and will consider them after the close of the preliminary meeting part 2. All procedural decisions will be set out in the Rule 8 letter, which will be published shortly after the close of the meeting. Now, typically, the preliminary meeting is a single meeting. It has been held in 2 parts for the past 1 year or so, since hearings format changed to virtual in response to government-imposed restrictions due to the pandemic. For this case, part 1 of the preliminary meeting is today, and at the end of business today, I will adjourn part 1. If someone watching the live stream or the recording wishes to make a representation, please do so by procedural deadline B on Monday, 16th of August. Should you wish to, you may also submit a request to attend preliminary meeting part 2, which must be received by procedural deadline B on Monday, the 16th of August. Now, preliminary meeting part 2 will resume on Wednesday, the 18th of August. It is important to note, however, that we will not be accepting any in-principle new submissions at part 2 of the meeting. All matters must be raised either here today or in writing by procedural deadline B. The purpose of preliminary meeting part 2 is only to allow the examining authority and other attendees to respond to what has happened here today and to the submissions received at procedural deadline B. Another important point is that if we do not receive any substantive submissions at procedural deadline B, we may decide to close the preliminary meeting in writing without reopening part 2. Further information about this can be found in the Rule 6 letter. Again, if any of this is not clear, please raise your hand function, use a raise your hand function on Microsoft Teams. No, that's good. I will move on to agenda item 2, remarks about the examination. When it comes to our approach to the examination, Mr. Parkin and Mr. Scriven will take you through the more substantive matters, and these are the initial assessment of principal issues, which is agenda item 3, and the examination timetable, which is agenda item 4. But before that, I have a few remarks about overarching matters relating to the examination. Firstly, as some COVID-19 relating restrictions still apply, the examination is starting as a virtual process. However, the planning inspector guidance is updated periodically to align with the government guidance, and on that basis, we will remain flexible. So that should public health controls allow, and as per guidance, it seems like it might, we may have the option of holding physical in-person events during the examination. The examining authority has not yet made a decision on this matter, and we will notify all parties of any changes in the format of future hearings with ample notice. We do, however, have an approach for accompanied site inspections, and of course these will be in person. Mr. Scriven will cover that under agenda item 4. I'm just going to invite a few representations now. I believe Cambridgeshire County Council, Mr. Poultney, would like to speak regarding the virtual approach to the examination. If you'd like to turn your microphone and camera on, Mr. Poultney. Mr. Tyrrell.
Good morning, Madam. My name is Francis Tyrrell. I'm a partner at Pinson Masons, and I act for Cambridgeshire and South Cambs and Huntingdon District Councils. I see Mr. Poultney's now joined us. I think he just wanted to confirm that the council were broadly content with the examination process, but I'll let Mr. Poultney now speak.
Thank you, Mr. Tyrrell. Yes, that was right. We just wanted to confirm that we were comfortable with the virtual arrangements and proceedings, which actually works quite well for us with lots of people working from home and remotely. So we just wanted to confirm we're comfortable with that. Thank you.
Thank you very much. good to know you're content with the process, but I just wanted to stress that there is scope for this to change in the coming weeks for potentially the second round of hearings. Okay, thank you very much from both. Secondly, I want to briefly touch on the legislative and policy framework for the examination of nationally significant infrastructure projects, or NSIPs. There is a lot of information in Annex B of the Rule 6 letter, so please do take some time to read that. I won't repeat it here, but I just want to highlight a few matters. The application is an NSIP under the Planning Act 2008 because it meets the thresholds in sections 14(1)H and 22(1)A, which is the construction of a highway, which is wholly in England. The Secretary of State is the Highway Authority. It covers an area greater than 12.5 hectares, and the new road will have a speed limit of 50 miles per hour or greater. The proposed development also includes the diversion of a high-pressure pipeline, which could be treated as an NSIP pursuant of Section 14(1)F. Besides the Planning Act itself, the predominant policy document is the designated National Networks National Policy Statement. It is often referred to as the NPS National Networks. NPS National Networks applies to this examination and to decision-making relating to this application. The NPS Energy Suite may also be applicable to matters relating to the gas pipeline diversion. Besides the Planning Act of 2008, examination procedure rules govern some aspects of the process. So you will hear us refer to Rule 6 letter or a Rule 13 notification or a Rule 17 request. These are all rules set under the examination procedure rules. These can be found on legislation.gov.uk website, and the link is on the Planning Inspectorate website. Thirdly, I want to emphasize that the examination is an inquisitorial and predominantly a written process. During the examination, the examining authority will test the merits of the proposed development to make a recommendation to the Secretary of State for Transport as to whether the proposal should receive consent in the form of a development consent order under the Planning Act 2008. The examination is an inquisitorial process in which the examining authority takes the lead in establishing what's important and relevant to the decision which the Secretary of State needs to take. So we should be looking for evidence of what is important, testing that evidence, testing the evidence that's put forward to see how robust it is. It's also largely a written process, so it's Section 91 of the Planning Act states that the examining authority's examination of the application is to take the form of written representations about the application. Now, there will also be hearings, but these should be understood as building on the foundations of the written submissions. So interested parties should seek to engage fully throughout the written process rather than think that they can wait for a particular hearing as an opportunity to influence the proceedings. Fourthly, I will mention that after a 6-month examination, the examination authority will take 3 months to write a recommendation report to the Secretary of State. The recommendation report will have at its core our recommendation as to whether the development consent order, the draft development consent order, either in its current form or as amended during the examination, should be approved. It will also contain recommendations on what land should be subject to compulsory acquisition if the Secretary of State approves of the DCO. Even if we do not recommend that consent should be given, we are required to still put forward what we consider would be the most appropriate DCO if the Secretary of State goes against our recommendation. The important point here is that all matters relating to the draft DCO are integral parts of the examination. The fifth and final point from me is about you and participating in the examination. This has been explained in the Rule 6 letter and the Planning Inspectorate's document, what is my status in the examination. However, I want to acknowledge the status of some specific participants here. We received a submission from Church Commissioners of England on the 16th of June 2021 regarding their status in the examination. I can confirm that you are an interested party in light of the Section 56 notice which was issued by the applicant. We also received a representation from East West Railway Company Limited on the 30th of June 2021. We think your contributions will be relevant to our considerations, and as such, you are able to participate in all aspects of the examination at all deadlines and hearings and accompanied site inspections. However, as this representation was received after the close of the relevant representation period, and you do not meet any of the criteria set out in section 102A and 102B, you do not have interested party status. Your status is that of other person. While this is not defined in the Planning Act itself, there is provision in the examination rules and procedures for the examining authority to invite other persons to participate in the examination. What you say will be given weight, subject to the merit and robustness of your evidence, just like any other evidence. The examining authority notes that East Cambridgeshire District Council and North Hertfordshire District Council have withdrawn from participating in the examination. If anyone has any questions, please use the raise your hand function on Microsoft Teams. No, I don't see any questions. I will move on to agenda item 3. Mr. Parkin, are we ready?
Thank you. From the agenda, you'll see that item 3 is the initial assessment of principal issues, which has been prepared under section 88(1) of the Planning Act 2008. You should have regard to Annex C of our Rule 6 letter for this item, which lists our initial assessment of principal issues for the proposed development. Is everyone who wishes to see a copy of Annex C able to? It's being shared at the present time. If you've got a problem, please raise the hand function. Okay, thank you. You'll see that the main subject headings are in alphabetical order. This is because there is no hierarchy of importance in the list at this stage. Annex C provides a framework of issues for the examination, which is broadly based on the matter set out in the National Network's National Policy Statement that Ms. Sahai mentioned earlier. You'll gather from the title that this is just an initial assessment. Over the course of the examination, some of the issues may be resolved in whole or in part, whilst others may be brought into sharper focus. The examining authority may also remove or add to the issues as the examination progresses. Today provides an opportunity for you to suggest a principal issue which you think we may have missed, or if you wish to comment upon those we have identified. I must emphasise again that this is not an opportunity to discuss the merits or otherwise of the proposed development. That will form part of the detailed examination of the application, which commences after this preliminary meeting has closed. It is not our intention to take any procedural decisions today, but we will listen to and will consider all representations made during the preliminary meeting. We've had 2 requests to speak on this agenda item, and we will hear those in turn shortly. The examining authority may then have some questions, and I will also give the applicant a chance to speak at the end of the agenda item. So it's the initial assessment of principal issues, and I will now invite the parties who wish to speak to this item to do so, starting with Cambridgeshire County Council and then the Environment Agency, although I'm not certain the Environment Agency are with us today. Given that we are recording the meeting, please could you remember to introduce yourself and who you are representing, and please ensure that your microphone is switched on before speaking. Cambridgeshire County Council first, please.
Thank you, Chris Pulteney, Cambridgeshire County Council, representing all 3 Cambridgeshire authorities. It was just a clarification, really, on borrow pits, the matters relating to borrow pits. We noted that there were some relevant representations on those, and I believe the first written question covers borrow pits also. It doesn't feature as a sort of specific bullet point in the list, so we were just wanting to check where in the principal issues that was being covered and whether that was going to be within land use on page C3 of Annex 3, please.
That's certainly our understanding, is that the borough pits would be covered under land use principal issue, and it will be something that we will come back to. I note that you've made these comments, and we will have regard to them as we go through.
Many thanks.
Thank you. Was that everything you wanted to say?
Yes. Thank you.
Yeah, great. Okay, thank you. Can I just double check with Ms. Gregory whether anyone from the Environment Agency is here, because they also expressed an interest in speaking on the initial assessment of principal issues?
Hello, Mr. Parkin. No, we don't have any representatives from the Environment Agency.
Okay. As such, we won't go into much detail on that. The Environment Agency did raise a few issues regarding flooding and drainage matters, regarding protecting main river navigation and groundwater protection. I'm satisfied that these are covered within the identified initial assessment, identified principal issues that we've looked at already. So I don't see that as being a particular issue for ourselves at this stage. Do either of my colleagues have anything that you wish to say on these matters?
No, Mr. Falcon, we're content. Thank you.
Thank you. Are there any other points anyone else at the meeting wishes to raise on the initial assessment of principal issues before we move on to the next item? If so, please use the raise hand function. I see Mr. Bastard has his hand raised. If you could, that's great. Thank you, Mr. Bastard. Sorry, you're on mute, Mr. Bastard.
Thank you, sir.
Just introduce yourself and who you represent again, please.
My name is Howard Basford. I'm solicitor and partner of the law firm DLA Piper UK LLP, and I represent East West Railway Company.
Thank you. And what
Thank you
was
for
it
that
you
reminder.
speak about?
So it's a very similar sort of question to the one raised by Mr. Pulteney on behalf of Cambridgeshire, but in this case it is checking, and I know you already do have this in mind, checking that the interfaces with other projects, and in particular East West Railway Company's proposals, are registered in the principal issues there. I had thought it might conceivably be under highways, network and structures, but it wasn't immediately apparent that you had those sorts of interfaces in mind in the principal issues. That said, we do have your questions on the topic, so we know it is in your mind.
Yes, I'm sure we have considered that within the principal issues.
Mr. Parker, may I just add to that? Yes, Mr. Basford, it has been considered in the principal issues. It's been considered as part of need for development and consideration of alternatives, and indeed as part of the highways network and design section. It is a matter that we will bring into focus at the issue-specific hearing next week, the agenda for which was published on Friday, the 6th of August. So it is something that we'd like to explore quite early in the examination. And as you've mentioned, it is being covered. It has been covered in the written questions in the initial first round of written questions. So it will be fully.
Thank you, Mum.
Thank you, Mr. Bassett. Can I ask the applicant whether they wish to make any comments on the examining authority's initial assessment of principal issues or any of the matters raised in response?
Sir, no, we have no further comments to make. Note the representations that have been made in your responses to them. We don't need to add to that.
Okay, thank you very much. I have nothing further to say on this agenda item. Should anything further arise in relation to this item, including from those watching the recording, or the live stream, please put this in writing to the examining authority by procedural deadline B, which is Monday the 16th of August 2021. Thank you for your participation. I will now hand over to Mr. Scriven, who will deal with agenda item 4 concerning the draft examination timetable.
Thank you, Mr. Parkin. So you will need to have Annex D, E and F of our Rule 6 letter in front of you for item 4. In the interest of brevity, I do not intend to read these out in full now, but I will highlight some key points. Annex D is the draft timetable, which you should be able to see on the screen shortly, if not already. Let's just check. Excellent. In light of your representations made here today and further considerations by the examining authority, we may make some changes before issuing the final examination timetable in a Rule 8 letter soon after the close of the preliminary meeting. I want to take the opportunity to highlight the importance of ensuring that information is submitted in accordance with the set deadlines. Whilst the examining authority does have the ability to accept late submissions into the examination, this is at our discretion and should only be in exceptional circumstances, as late submissions restrict the ability of other parties involved in the examination to respond to the information and can therefore jeopardise the examination timetable. It is important for you to note that if you do submit something late, there is always a possibility that it may not be accepted into the examination. Before moving on to the provisions in the draft timetable itself, I want to re-emphasise a point Mr. High has already made, that the National Significant Infrastructure Project examinations are inquisitorial and written processes. There are provisions for certain types of hearings, and while these are important, the central part of the examination is the written process. I will first take you through the opportunities in the examination timetable when you can make written submissions. I will then talk about hearings, following on to accompanied site inspections. As these matters are all linked, rather than invite comments as we go, I will invite comments from those wishing to speak at the end of this agenda item. Finally, I also want to touch on managing change during the process. So written submissions can be received in the following formats. Relevant representations during the pre-examination period, and thank you all for your submissions. The next opportunity is through written representations, which should include each party's detailed case and set out the reasons why they support or oppose the application, with evidence as far as possible. Written representations are requested from parties by deadline 1. Notice of the deadline for receipt of written representations was set out in our Rule 6 letter and in Annex F of the Rule 6 letter. I'd like to highlight an error in reference in here. The relevant examination procedure rules are Rule 3 and Rule 10 respectively. We will correct this error when we issue our Rule 8 letter. The examining authority will issue one or more rounds of written questions. We gave advance notice to parties of our intended first written questions on the 21st of July. We will formally issue the first written questions with the Rule 8 letter, which will finalise the timetable. 2 further rounds of written questions, if required, will be issued on the 15th of October and the 22nd of December. We can also, if we consider it necessary at any point during the examination, issue a specific request for information from named parties. This is known as a Rule 17 letter. For both written questions and Rule 17 requests, the way you participate is by either responding to questions or by commenting on other responses received. Various deadlines through the examination provide opportunities for responses and comments. So moving on to statements of common ground. In the Rule 9 and 17 letter issued on the 2nd of July, the examining authority has set out in detail requests with respect to statements of common ground, with named parties and the range of topics we expect the statements to cover. The deadline to receive these statements are deadline 1, deadline 3 and deadline 5. The final statements of common ground are expected on deadline 8. In addition to those requested, I understand the applicant is also intended to provide a statement of common ground with the East West Rail Company, and this would be welcomed by the examining authority. The Rule 9 and 17 letter also gave notice and provided a deadline for local impact reports. Local impact reports are submitted only by local authorities, represent the broader views of their community, and should be presented in terms of their positive, neutral and negative effects, based on the information available at the time of writing. The report is distinct from any representation a local authority may make on the merits of the application. Local impact reports are expected from Bedford Borough Council, Central Bedfordshire Council, Cambridgeshire County Council, South Cambridgeshire District Council, and Huntingdonshire District Council, all at deadline 1. I ask that interested parties review all the deadlines and submit any comments on the proposed timetable, either at the meeting today or in writing by procedural deadline B. So moving on to hearings. There are 3 different sorts of hearings under the Planning Act 2008, set out under section 91, 92, 93 and 94. These are open floor hearings, compulsory acquisition hearings and issue-specific hearings. The first round of hearings will be on the 18th and 19th of August. The Rule 13 notification of these hearings was sent with the Rule 6 letter, and that's Annex E. The deadline to receive confirmation of attendance was procedural deadline A, and thank you all for your responses. Following the close of Part 2 of the preliminary meeting, which marks the start of the examination, an issue-specific hearing is scheduled. The purpose of the hearing will be to better understand several strategic matters associated with the proposed development as outlined in Annex E of the Rule 6 letter. An agenda for the first issue-specific hearing was issued on the 6th of August, as well as draft agendas for the open floor hearings, I believe. At this first issue-specific hearing, we particularly want to focus on high-level issues relating to the need of the proposed development, including the intended East-West Rail Scheme, the recently published Decarbonising Transport document and revised National Planning Policy Framework. Also, assessments of alternative junction designs at the Black Cat Junction, environmental effects including the pipeline diversion, habitat regulations assessment and good design of flooding, and some key matters relating to the draft DCO. I should stress there seems to be a lot to cover there, but we really want to focus on the strategic high-level matters. We appreciate that these matters are covered in some detail in the examining authority's first round of written questions. At the hearing, we are looking for clarity, as I say, on the applicant's strategic approach. We expect the representations at the hearing to set the scene for the more detailed responses to written questions, the first round. An open floor hearing is an opportunity for individuals and community groups to put their views forward verbally to the examining authority. All the submissions should be based on representations previously made in writing and not simply repeat matters previously covered in a written submission, but rather provide further detail and explanation to help inform the examining authority. I believe we have 5 parties requesting to take part in the open floor hearings at this point, with attendance also requested from local authorities and the applicant. We are considering whether the evening open floor hearing should take place based on the numbers. If anyone wishes to make comments on this matter, please do so when invited later in this agenda item or in procedural deadline B. We have also seen the comments from interested parties within the relevant representations and those received at procedural deadline A in relation to appearing at a compulsory acquisition hearing. The case team are able to assist with any questions you may have about the technology required for these events. The draft timetable reserves time for further hearings, which commence on the 20th of September. We will issue the Rule 13 notification for these hearings, with the Rule 8 letter after the close of the preliminary meeting Part 2, and detailed agendas and itinerary will be published a week before the hearings and the accompanied site inspections. Further rounds of hearings are also identified in the timetable, only if required, week commencing the 29th of November, as well as the 8th of February. The examining authority will provide at least 21 days notice before confirming the dates of any hearings. Upon receiving the notification for hearings, you will be asked to confirm attendance by a particular deadline. For the hearings in September, that will be for confirming attendance by deadline 1. As mentioned earlier, at this stage, our starting point is that all hearings will be held virtually, and our draft timetable assumes this. Each round of hearings includes an additional reserve date scheduled for the following week. Typically, we will only utilise this if absolutely necessary, for example, in the event of technology failure. If possible and necessary, we may make a decision to hold the hearings during the week commencing the 30th of November as in-person events or as some form of hybrid event. We'll give as much warning as possible of any decisions on this. So please do keep an eye on the project page of the National Infrastructure website for any announcements. Right, and on to site inspections. You should be aware that we have already undertaken a round of unaccompanied site inspections on the 30th of June and the 1st of July. These were carried out from public land only, including various public rights of way, where we observed key locations of the proposed scheme and associated development, the proposed construction, traffic routes and nearby settlements, as well as various places referred to in relevant representations. Notes of our unaccompanied site inspection were published on Monday, the 5th of July, and can now be viewed on the project page of the National Infrastructure website, and the reference for that is EV-001, so I do not propose to read these out now. It's possible that we may undertake further unaccompanied site inspections during the examination process. Turning now to accompanied site inspections. These are generally to locations not publicly accessible. You will note that the draft examination timetable included a request for nomination of sites for accompanied site inspections by interested parties by the 3rd of August, that was Tuesday the 3rd of August, and procedural deadline A. I understand we have received 6 submissions, including the joint responses from the Cambridgeshire councils, and thank you all for your consideration and time. If you haven't already done so, it would be helpful to provide an annotated map showing these points of interest for procedural deadline B. At deadline 1, the applicant will prepare its proposed itinerary based on your nominated sites and the applicant's own proposals. The final itinerary for the accompanied site inspection will be issued by the examining authority alongside hearing agendas at least a week in advance of the event. The first accompanied site inspection will be held one day during the 21st to 24th of September. If we were unable to cover all sites on that day, we may hold a second accompanied site inspection during the week commencing the 30th of November. Following our unaccompanied site inspection, the examining authority has a good understanding of the locations visited. Therefore, it is unlikely that we will need to visit all the sites again in any accompanied site inspection. Such an inspection will only be necessary to view land where there is no public right of access or with no clear view from public viewpoints. I should stress the examining authority will not hear evidence or other submissions during the accompanied site inspection. At the present time, the government-imposed restrictions will not affect our ability to hold accompanied site inspections. Needless to say, we will still take all reasonable precautions as required. If government restrictions and our own guidance changes prior to the accompanied site inspections, we will issue special instructions with that final itinerary. So, moving on to any comments on this agenda item, which I'm aware there are some. I will now invite comments on the agenda item. We won't make any procedural decisions today, but we will be considering your requests and suggestions when we finalise the timetable in our Rule 8 letter. When asked, can you please turn your mic and camera on and introduce yourself? So I'm aware that we have received a joint response to the Rule 9 and 17 letter and the Rule 6 letter from the following local authorities. And that came from Cambridgeshire County Council, South Cambridgeshire District Council and Huntingdonshire District Council. I also understand Bedford Borough Council agree with the comments made. Just bear with me a moment. I can see we've got a hand up from Mr. Linus. I can see Mr. Tyrrell's face, so I'm a bit confused. Right, so can I take Mr. Linus first, please?
Thank you, sir. Scott Linus for Highways England. We have a few points, many of which have been set out in the letter of the 3rd of August. Perhaps the most efficient way of dealing with them is to take specific points we have on a couple of the deadlines. I know other parties have points to make, and then we can leave some ancillary points that we raised in the letter to a later stage, if that's acceptable to you, sir. I was intending to go through the local authorities first, and then East West Rail, as I'll come on to, and then invite comments on those specific items, and then come to you at the end for fuller comments. That's absolutely fine. Thank you, sir. Okay. And Mr. Tyrrell, was there any specific comments from you now, just on the process?
Thanks, sir. Francis Tyrrell from Pearson Masons, acting on behalf of Cambridgeshire County Council, Huntingdonshire District Council and South Cambs District Council. As you noted, the councils wrote to you on the 6th of July following the Rule 9 and Rule 17 letter, and also wrote again on the 2nd of August following the Rule 6 letter. The second letter builds upon points made in the first letter. Broadly speaking, the proposed timetable at Annex D is very compressed at the beginning, is quite compressed at the beginning compared, for example, to other examination timetables previously and also currently. For example, the A428 North Tuddenham timetable adopts quite a different approach. The reason why we say it's compressed is particularly from the local authorities' perspectives, there is a lot to be done by deadline 1. They have to effectively submit the local impact report, and I'll come back to that shortly. There's some issues around doing that by that deadline, but also their written representations, their responses to your first written questions, and also obviously attempt to agree a very long statement of common ground with the applicant. Added to that, obviously, and I know this will be the same for other parties, but obviously they have probably different resources than the local authorities. The officers will need to be attending a number of hearings this month as well. So that there is a problem just in terms of time periods, in terms of resource, but also, and these are the points we made in our letters that are referred to, the useful sequential nature of documentation is not followed here as it could be, or as well as it might be. In particular, the provision of information from Highways England that would naturally follow from the submission of their written representations, for example, and their responses to other parties' written representations being taken into account by the local authorities in the local impact report. And we feel that would be much more useful for local authorities, but also much more helpful for yourselves if the local impact report could be submitted later to allow that information to be processed and taken into account. Accordingly, and this is the first change that we have suggested, we would propose that deadline 1 is extended by 2 weeks until the 14th of September. The main motivation for this would be so that the local impact report could be provided later, but provided after the important information has come in. And on that basis, we propose that the deadline for the applicant to respond to the relevant representations should remain at the 31st of August. So then you would have this sequential nature, which would be of use. That change to deadline 1 to the 14th of September, we've suggested wouldn't really necessitate any other changes to the overall programme or changes to other deadlines. Deadline 2 falls on the 5th of October, which would give you 3 weeks following that revised date for deadline 1, which would be ample time to carry out the activities required by deadline 2, which is largely less amount of work, to be frank, than the activities building up to deadline 1. So that's the first sort of significant change. I don't know if you want me to pause there in relation to deadline 1, because I think Mr. Linus was suggesting perhaps we did it deadline by deadline, but I can carry on in relation to the comments the authorities have on the other deadlines too, if you'd like me to. I think Ms.
I'd be content to. I'll just explain on this deadline 1 issue, I think, first. So do obviously note those comments and appreciate the timing of the deadline 1 does fall in the summer holiday period as well. So to provide notice of our request for information, in addition to the Rule 9 and 17 letter issued the 2nd of July, which gave over 40 days notice to parties, we also encourage local authorities to commence preparation of the local impact reports around about almost 6 months to go to the day on the 12th of February. And the lead-in and preparation time for local impact reports is also highlighted in Advice Note 1. As you're aware, these local impact reports play an important role in the examination, and we do acknowledge that. However, you will have the opportunity to comment on the applicant's responses to relevant representations at deadline 2, and those submissions carry weight in our considerations as well. I'm also unaware of other NSIP examinations where the deadline for local impact reports has come after the applicant's responses. And I've also got to be mindful on the resources at our end in dealing with the materials that come back. So we will, though, consider these requests carefully, and any changes will be made in the Rule 8 letter. As I said, we're not going to make a decision today on these sort of items, but we will confirm in our Rule 8 letter.
So, thank you for those. Sorry.
Yeah.
I was saying thank you for those comments.
Over to you if you want to respond on that.
Thank you for those comments, and that's understood. Also, I think it's not the lack of notice which is the authorities' concern. As I said, it's predominantly having a sequential nature, so that they have sufficient information to most usefully provide information to the local impact report to you, I mean, you mentioned you were unaware. I mean, just by way of example, the A47 North Tuddenham application, the Rule 6 letter for that indicates the written reps are due at deadline 1, which in that case is 3 weeks after the preliminary meeting. And then local impact reports and responses to first written questions are then due at deadline 2.
Deadline 2. Right.
So
We'll take these comments on board, okay, as I say. Okay.
Thank you.
Mr. Scriven, is it just worth me adding a point here? I think all comments are very well made, and they are very helpful indeed. It's just worth saying that there is a distinction between local impact reports and other representations made by local authorities. So, for instance, your statement of common ground, understood, statement of common ground will no doubt be a long one, but there are 4 other opportunities for you to do that over the course of the examination to finalise different aspects of it. The second point to make is that we see the local impact report again as being distinct from your commentary on things like the applicant's response to relevant representations. So, you know, they all carry weight. So all I'm trying to say is that I think it's, while the local impact report plays a very important role in the examination, all your other representations through the course of the examination will carry a lot of weight. It's also worth just highlighting that starting with the adequacy of consultation response and your relevant representation, there has been a note from local authorities about needing more information from the applicant. So that has been a point that we, as the examining authority, have had has been a key consideration as we were drafting the timetable, because we wanted to make sure that there was adequate time during these 6 months to make sure that all that information that local authorities were wishing to see was made available to them, and any further negotiations that need to happen, there was enough time in the timetable to do that. So do bear that in mind as well, that has been one of our key motivations. But that's all that I wanted to say, Mr. Scriven, and I'm just wanting to say, repeat that I think all points are well made and of course are being considered.
Okay. Was there other comments to make, Mr. Tyrrell, as well?
Yes, we did have some further comments. These are all as set out in our letter of the 2nd of August.
Yeah.
So I won't labour them too much, but just to reiterate, we proposed also that deadline 3 perhaps should be extended by 2 weeks. That's because we thought allowing 2 weeks to respond to any second written questions was perhaps too short a period of time. I think also, if I recall, the applicant had also made comments in relation to that, and obviously they'll touch upon that. We thought deadline 3 could be adjusted without any consequential change to deadline 5. So again, wouldn't necessarily prejudice the overall timetable in that respect. And there'll be limited consequences from that. So that was the main point on that. And then I think also, as the applicant has also raised, the deadline in relation to the third written questions falls immediately after the Christmas period, and perhaps that could more usefully be extended for a short period, just to make that a little bit more user-friendly, I guess, for those involved in producing that documentation. And also, it seems traditional around Christmas that we have some sort of deadline, I know, but if it could be avoided or extended, I think it would be useful for council officers as well as everyone else involved.
Okay.
Thank you.
Do we assume that the council, is there any form of close down period for you over Christmas?
Can I ask Mr. Portney to answer that?
Yes, thank you for the question. I'm not sure we know the answer yet, but for this year, I don't think we've been informed. But certainly on previous years, we have had a formal close down period, probably for the last 2, possibly 3 years now, certainly for Cambridgeshire. I'm not sure about the other authorities, but we can provide that information to you should it be helpful.
Yeah, I think it would be. Yeah, okay, thank you.
That's fine, thank you.
Okay. Okay, so is that it on from the Cambridge County Councils, Cambridge County Council on behalf of the Cambridge authorities, and also Central Bedford? Yeah.
Yes, thank you. So that is all that we have. in relation to Cambridgeshire County Council, Huntingdonshire Council, and South Cambs District Council. I don't speak on behalf of the Bedfordshire councils, but I think they have indicated their support for the letter that we issued.
Yeah, I have nothing further. Thank you.
Thank you. Okay, so I'm going to invite comments from, I think, the East West Rail Company wish to talk on this matter then as well, on this agenda item.
So I don't have anything in particular to say about the process for the examination. We are working already with Highways England to advance discussions on things like statements of common ground and so forth. You have our submission in relation to the accompanied site inspections, and I have just noted your request for us to set out an annotated map by deadline B to assist you. So, sir, unless I can help you further, that is fine from our point of view.
Okay, thank you very much. Okay, so just before moving over to the applicant, I just want to double check was no one else wish to speak on this item? If you could raise your hands, that would be good. It doesn't appear so. So I will invite the applicant to make their comments on this. Mr. Linus.
Thank you, sir. Scott Linus for HE. Can I take the deadlines in turn, starting with deadline 1, if I may? We do have some reservations and concerns about it being extended as far as the 14th of September. I won't repeat the point that you made, sir, in your initial response, but I would add that one further point to bear in mind is at the moment there is the possibility of issue-specific hearings between the 21st and 23rd of September. And from both our and frankly your point of view, we're concerned about the receipt of papers and material from the local authorities that soon, potentially in advance of an issue-specific hearing. Doesn't give either us or yourselves much time to consider the local authorities' position in advance of trying to determine what an agenda might be, for example, for any issue-specific hearings that are coming up. Secondly, if it were extended to the 14th of September, that would leave us until the 5th of October to respond, and there would be potentially quite a lot of work for us to do, and we would not be keen to truncate that period, certainly not as far as the 14th of September is concerned. Overall, we don't intend to ask you to vary the deadline for the submission of our work. We are working on that basis, and we will do that. If you were minded to accept any of the points that were raised by the local councils, notwithstanding what I have said, perhaps the only reasonable compromise would be to extend the submission of the local impact reports by 1 week. We don't actually see that there's any need to delay the preparation of a local impact report until the local authorities have seen our material. We don't necessarily see that that should be decoupled in that way. But if you were to accept that position in principle on behalf of the councils, if any extension were to be given, we would respectfully suggest that that's limited to, say, a week or so that the points that you and I have mentioned, sir, can be mitigated to a degree. As for deadline 3, yes, as has been mentioned already, we would support an extension to deadline 3 as intimated in our letter of the 3rd of August. We're reasonably relaxed about it going by 2 weeks, given that the next related affected deadline would not be prejudiced, we say, by extending it by 2 weeks. Deadline 3 at the moment is 1st of November. if that were to be delayed by 2 weeks, the next really related deadline is deadline 5 on the 14th of December. So we think there is scope to extend, bearing in mind half-term holidays as well. We had thought a week, but I think on reflection, the 2 weeks that's being suggested would be comfortably achievable. The third point on deadlines relates to deadline 6. We know the councils have asked for an extension from the 11th of January next year to the 14th. We had thought initially that we should ask for an extension to the 18th of January, largely for the same reasons as we mentioned already, the Christmas period, holidays, and so on. We realise that if that extension by a week on deadline 6 were to be pushed out to the 18th of January, it was probably going to be sensible to align that with an extension to deadline 7 from the 25th of January by a week as well. We think that would not put undue pressure on deadline 8 because the timetable could revert to that. And we're, of course, extremely keen that there isn't excessive pressure put on the end of the deadline, the end of the examination period. But we think to avoid any issues over Christmas, extending it deadline 6 and deadline 7 by a week would be feasible. If, contrary to that, you're concerned about extending deadline 7, then the fallback position from our point of view would be to go for the 14th of January rather than the 11th January at deadline 6.
Okay, that's helpful. Thank you. Okay. Do either of my colleagues want to comment on? Oh, sorry, we've got Mr. Tyrrell's got his hand up, so I'll just invite comments from there first.
Thanks, Francis Tyrrell from Pinson Masons on behalf of the Cambridgeshire authorities. Just wanted, and we've heard what you said, obviously, in relation to the comments about producing it on the basis of the information we have, and this is in relation to the local impact report in particular. Obviously, and we also take on board and are accompanied by the fact that you've sort of picked up on our concerns about information being provided, and that's been taken into account. We're aware, obviously, also of the written questions and some of the matters that you've put into those to elicit information as well. Just wanted to test the appetite, really. Obviously, if the local impact report goes in on deadline 1, having also heard what the applicant has said, we wanted to check whether a supplement or an update to that local impact report once further information had been provided, particularly, for example, in relation to modelling, whether that would be sort of received as an update to local impact report, and whether we could sort of arrange things in that matter as well. Not saying one would be necessary, but the councils do have some doubts about the level of information they have at the moment and whether or not they can usefully comment on the impacts. And this is not from the point of view of written representations, it is classic local impact report territory, whether or not we could sort of supplement the local impact report at a later date.
May I take that one, Mr. Scriven?
You may take that one, yes.
Mr. Tyrrell, that's an interesting question. I will have to take that away. It is not traditional for local impact reports to be submitted twice during an examination, especially because it is as it's written in Advice Note 1, it is a snapshot in time, and it is supplemented by other representations which are distinct from local impact reports submitted by local authorities, such as the Statement of Common Ground. I fully take your point that the local impact report has a particular role under the Planning Act of 2008. But leave that with us. We will take that into consideration and we will respond to it either in our Rule 8 letter or at preliminary meeting part 2 should we decide to open it again.
Thank you, Madam. Just to add, obviously, this is not something we'd be aiming for, but just bearing in mind, as you say, the role and status of the local impact report in order to make sure it is as useful as possible. And it would be something to do, I think it was something that we would look to do as soon as could be done. And also not because otherwise it doesn't become useful.
And I think you use 2 words, which is helpful: an update or a supplement. And I think that is the clue for us, is that but particularly with information regarding to traffic modelling, which the local authorities raised in their adequacy of consultation report. So it's possibly the supplement is what we might be able to consider as distinct from being an update. Okay, we will definitely take that into consideration. Thank you very much.
Yeah. Mr. Linus, can I bring you back in, please?
Yes,
so just before coming on, there's as you've seen, there's this comment, the comments around the availability of information to the local authorities to be able to make their local impact reports, and to really help with the process, it would be useful to know when that sort of information, if it is going to be made available to the local authorities in the timescales that we've been talking about, for them to be able to write these local impact reports as they wish to. If it isn't going to be made available, then I think it would be useful to know.
Thanks, Sir. Scott Linus for Highways England. Well, I think from our point of view, we had taken the view that adequate information had already been provided in order to enable local impact reports to be submitted. I think if any of the local authorities are raising concerns about an absence of information, I think we really need to be told specifically why the information that's been submitted isn't sufficient and what they need. But our position at the moment is that we think sufficient information has been provided to local authorities to enable those reports to be prepared. The second point I would make is obviously the local impact reports have a discrete position in the examination process, but they must be seen in the context that there is a series of deadlines at which local authorities are able to supplement their position based on discussions and further information that's released through the examination process. So we don't see the preparation of the local impact report as somehow necessarily providing the definitive final position of the local authorities, because they'll have the opportunity to do that through the rest of the examination. And the realisation of that shouldn't, in our view, avoid or prevent the submission of the local impact reports under the current timetable.
Okay, thank you. It would be very useful, obviously, if the applicant and the parties can pick these matters up offline then.
Yes, sir. Scott Linus for AG. I was going to say towards the end, obviously, we will welcome engagement as soon as possible with any of the local authorities, and we're doing our best to put that in place through the framework of the Statement of Common Ground process. And we will do our best to advance these matters, both before the local impact reports need to be prepared and generally throughout the examination process. So we too take that on board, sir.
Okay, thank you. Thank you. But so I think on this item then, this part of the item, we will move on unless there's no other hands up at this point in time. So if I just move on to...
Very sorry to interrupt, but I think there was some ancillary matters that were raised in the applicant's response, procedural deadline A response. And there's just a couple of things that I wanted to clarify. One was that the applicant has requested the documents be published on the project webpage within 24 hours. And I just wanted to clarify that that they will be published within 48 hours, not quite 24 hours. So I hope that's acceptable. And then, and they've clarified that they will be updating a COVID strategy at deadline 1, and we would welcome that. So Mr. Linus had referred to some ancillary matters that they wanted to raise, and I'm just confirming that that was it, unless there's anything else.
Scott Linus for Highways England. Ma'am, thank you very much for that. There were a couple of other points that I was going to raise, noting your comments already. If I can take them in turn then, please. The first one relates to deadlines 2, 5 and 8. It's nothing to do with the deadlines themselves, but you'll note that those deadlines follow fairly quickly after a suite of dates for potential future hearings. And we just want to put a marker down that there is at least a possibility of some potentially significant work needing to be done arising out of those hearings. And we're just making a respectful request that should any significant actions be required, that we review an appropriate deadline for specific actions as and when the need for them arises at those hearings. The second point relates to further hearings, and it probably touches upon the virtual nature of hearings as well. It's this: we'd be very grateful for notification of whether reserved hearings are going to go ahead as soon as possible in advance, so that we can arrange for the requisite publication in newspapers. Obviously, there's a lead-in time to get advertisements and so on. So, for example, with hearings in the week commencing the 20th of September, we would need to publish a notice on the 25th or 26th of August, and we'd need to find out by the 16th of August, say, about the hearings, so that we could put notices in the relevant newspapers. Related to that, we note entirely the comments about maintaining some flexibility over physical hearings, physical attendance at hearings. It goes back to the same point. Obviously, whether or not that can feasibly be done will depend potentially on the nature of the issues to be raised at the hearing, and therefore the number of attendees, and therefore whether or not a venue can be found which will safely house or accommodate everyone who needs to be there. And obviously there's a lead-in time that's required even before the publication of the hearing. So if there is flexibility to be exercised, we are very grateful for your indication, ma'am, that you would give sufficient notice, because there's actually a reasonably convoluted process that needs to be gone through before we can actually arrange that. Thirdly, ma'am, as far as the potential issue-specific hearings is concerned, can I just say on behalf of the client, we're very grateful for the early indication of the agenda items for issue-specific 1. That was part of a wider issue that we raised in our letter about how helpful we find it to have advance notification of the agenda items in as much detail as possible, because to help you, it helps us get the relevant experts lined up and prepared as soon as possible in advance. So we would be very grateful if a similar process can be followed for any further issue-specific hearings. So I think as far as the draft timetable is concerned, those are other points we wanted to raise. There's some other matters that I raise under the next agenda item, if that's acceptable.
Thank you.
Mr. Linus, can I just come back to you on just a couple of matters? So the point about your second point, physical event and notice given with respect to physical event, absolutely noted. And we will make sure that that lead-in time for you and other parties, for instance, local authorities' way of working has changed considerably over the years, over the last few months. So we will give you as much notice as possible. The first point about hearing notification, for the 20th of September, you said that you would need to have the newspaper adverts out on the 25th of August, which is fine. But you said that you would therefore need notification by the 16th of August. So do you really need a week and a bit notification to be able to put adverts out in the newspaper?
Yes, I think that my instructions are that we would need that long, because there's obviously internal process that need to be gone through even before we contact the newspapers.
Okay.
Yes, and it's because I think the newspapers are issued on a particular day, so it's not necessarily a neat timing in advance.
Right.
You have to give a certain period to allow the newspapers to set themselves up. So we can't necessarily go to the newspapers on a daily basis. There will be a certain time that we have to go back to the newspapers to achieve a certain slot, which is why I think in the letter we suggested the 16th. Yes, I mean, there may be some flexibility in that, but I think ideally the 16th.
Okay. Okay, that's noted. Physical event, we've covered that. Issue-specific hearing agenda, yes, for the it is our intention to at least send out the notification as early as we possibly can. And with the notification, we will have a bullet point list of the matters that we intend to cover, with the detailed agenda, like the kind that went out on the 6th of August, last Friday. That agenda will only go out a week in advance. So I think that is the intention. Does that work with what you were saying?
I mean, if it were at all possible, obviously we're in your hands, and we understand the work that has to be done to prepare that. If it were at all possible to have a little bit longer than a week, it's a case of us not just lining up the experts, but making sure that they can work through each of the sub questions so that they're prepared to answer those. And I think it's really as soon as possible, really. Yeah. But we entirely understand the constraints that you're working to as well.
Yeah. No, that's helpful. Okay, that is good. That covers it for me. Back to you, Mr. Scriven.
Thank you. I can see Mr. Basford's got his hand up, so don't know if you wanted to make these comments now.
This is a very short point supporting, hopefully, the good intentions of Mr. Linus and their acceptance by the panel. One of the things on other DCO examinations that has been extremely helpful on the part of the panel, from the point of view of applicants and participants, has been if a reading list of the documents of particular interest to the examining authority can be published with the questions, then the experts and advocates can turn to that rapidly. That's been found helpful. I put that to you as a suggestion rather than a forceful submission. Very useful when it happens.
Okay.
Okay, thank you. Comments noted. Thank you. Okay, so I'm just going to move on to managing change in the process now. So the examining authority know that a lot of work is going on behind the scenes to try and resolve points between parties. We're trying to retain as much flexibility in examination timetables to ensure we can accommodate the examination of issues that might arise without the need to change the timetables later in the examination period. However, the examining authority would like to take this opportunity to advise that there comes a time when effectively it becomes too late to accommodate any changes of substance because of the need to consult and take other procedural steps to properly examine the proposed change. And Advice Note 16, available on the National Infrastructure website, explains this in more detail. Sorry, I can see there's a problem here with network quality. Can everybody hear me?
I can hear you very clearly.
Okay, thank you. That's good to know. I will just close that. There we go. Right, so let's go back a little bit. Here we go. So Advice Note 16 on the National Infrastructure website explains this all in more detail. For this examination, there's really a point where there's a cut-off for any significant changes, and that's around deadline 3. So it's to enable parties sufficient time to digest and comment on the changes, and also inform the need for any scheduled hearings at the timetable. Can the applicant confirm if any likely changes are to be forthcoming, and if so, any indication of when this might be, please? Thank you.
Sir Scott Linus for HE. I have no instructions that there are any significant changes, but the comments that you've made about timings are noted.
Okay, thank you. And moving on to the report on the implications for European sites, which I shall refer to as the REIS. It's a bit of a mouthful. So where an applicant has provided a no significance effect report or a habitats regulations assessment report with the application, the examining authority may decide to issue a REIS during the examination. The REIS is a factual account of the information and evidence provided to the examining authority on habitat regulations assessment matters during the examination up to the date of publication of the REIS, for the purposes of enabling the Secretary of State as competent authority to undertake its habitats regulations assessment. It's not the examining authority's opinion on these matters. If a REIS is required, comments will be invited on its content by the examining authority for submission at deadline 6. Any received will be taken into account as part of the examining authority's recommendation to the Secretary of State. So thank you all for your comments on this wider agenda item, and I will now hand back to Mr. High for any other matters.
Thank you, Mr. Scriven. I just want to acknowledge very quickly that we've not had a break, even though I promised it at 11. Should anyone want a break, please raise your hand. But I believe with questions we should be able to bring this meeting to an adjournment fairly soon. But if you did want a break, please raise your hand. No, I will continue. I'm assuming my colleagues are happy to continue as well. Agenda item, just any other matters. We've covered timetable in quite a bit of detail, and as I said, very good points. We will take that into consideration, and it will be issued with our Rule 8 letter, our final timetable. Were there any other matters from anyone? Mr. Linus.
Thank you, ma'am. Scott Linus for Highways England. Just a couple of brief matters, please. First of all, the accompanied site inspection. We were asked about timings and length of time for that. Just to record our position that we've read the submissions from the other parties, for which we're grateful and which you've mentioned already. Our estimate is that 2 days would be needed for the accompanied site inspection to allow for travel between sites and the basic logistics of moving around. As for dates, we can be flexible within the 21st, 22nd, 23rd, 24th and 28th of September. Any of the 2 days within that period would be acceptable to us, and we welcome any indication from the panel either about further sites which need to be taken into account as part of that visit, or any preference for dates, but we're content to be flexible within those that I've mentioned. The second point relates to open floor hearings. I understand we were asked to confirm whether we'd be seeking to respond orally at those hearings in response to comments that were made by others or in writing after. We're content to provide comments in writing after, and we note and welcome the panel's review as to whether or not both open floor hearings are required in the light of the number of representations that may be made. But just to confirm, we're content to put in writing any responses rather than deal with those orally at the hearings, if that's acceptable to the panel.
So both points noted, and yeah, it is our intention with the Rule 8 to send out the notification for the hearings and the accompanied site inspection. So what's happening on which day should be very clear then. And comments in writing after the open floor hearing would be our preference as well. So thank you for that. Any further points?
Anything further? No. No, thank you very much, ma'am.
Thank you, Mr. Linus. Any other points from anyone else at the meeting? No. Okay, I am content to adjourn the meeting shortly. Just as I said before, the purpose of the adjournment is to enable people who are watching this event on live stream or catching up afterwards using the recording to have the same opportunity to have their say as you have had here today. And they can do that by making written submissions by procedural deadline B, which can include a request to be heard orally at preliminary meeting part 2. Once again, I just want to remind everyone that we are not accepting any in-principle new submissions at preliminary meeting part 2. And indeed, if we don't receive any substantive submissions by procedural deadline B, we may not reconvene preliminary meeting part 2 and close it in writing. Does anyone have questions about preliminary meeting part 2? No? Okay, that completes our business for today. It is now 11:31 a.m. on the 10th of August 2021, and I adjourn this preliminary meeting until Wednesday the 18th of August at 10 a.m. Thank you very much for your patience and participation.